Hi, everyone, and welcome to Raw Law, where we answer your questions and we talk about your comments. It's all about you, the viewer, on this episode. So welcome, everyone, and thank you for being here. My name is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and I handle all types of personal injury cases like trip and falls, car crashes, truck accidents, construction site injuries, ceiling collapses, types of apartment injuries where people slip and fall, trip and fall due to any kind of unsafe condition. And we go to court and we do what's known as civil justice, where we get people as much compensation as we can under the law through the court system and through going to trial. So, yeah. So thank you, everyone, for being here. Let me see who's here. I see we have a few questions in the chat already. So let's get into it. Let's see here. We have a comment here from Truth Seeker. Truth Seeker says, "Hi, Arkady. The insurance company finally accepted my Brady Cardia. And where would you start negotiating with them? Would you ask for the policy, which is over $1 million?" And he said, it's hard to find cases with Brady Cardia when it becomes an occupational disease due to your work environment. Okay, yeah, so that would depend. If it's an occupational injury from like a workers' comp context, then you might want to, have a workers' comp attorney handle it for you who's knowledgeable, because those would be different numbers than what I'm talking about. So when I give my numbers, like results that I've won, like $1 million or whatever it is, I'm mostly talking about personal injury where you file a lawsuit. Like, for example, a car crash, those kind of cases. So I'm not familiar with workers' compensation numbers. They probably are going to be lower than personal injury numbers, because personal injury are the third-party injury lawsuits, while the workers' comp is more like to compensate the worker for not being able to go to work, lost wages, medical bills, things like that. And they have like impairment ratings. They work a little differently. So I'm not too, familiar, because I don't do that. So I'm not too familiar with that. But yeah, you could start high, start with what you feel like the case is worth. I don't know, Brady Cardia, I've heard of it. I know it's a heart condition, but I don't know, depending on how severe it is and whether it was caused only by the work environment as opposed to something else, right? It could be genetic or it could be caused by something else. So if you have strong causation and you have, serious injury, depending on the severity of it, you could probably make a higher demand. It doesn't really hurt. You could always come down and see what they're willing to offer you. That's good that they accepted it, though. That's good. So congratulations on that. That's really good. Okay, and then Cole says, hi. Hi, how are you? Great to see you. Steven says, why would you go for big verdicts if it's almost guaranteed to be appealed by the defense? Does the court ever uphold the verdict? Yeah, they do. They uphold the verdict. That happens a lot. The only reason you could appeal the verdict is if it's against the weight of the evidence. So meaning you have all the evidence and the weight, like how strong the evidence is, how much it weighs. And then they basically say, look, but you're giving like $100 million. There's just, this evidence does not justify $100 million. It's just too much. We have to lower it down, right? So they've had cases like that. In fact, there was one case for $100 million. And I think they knocked it down to 20 million, but it's still a lot, And if you get a verdict of like 7 million, 10 million, that could be sustained as being fine. So it's not like every case gets knocked down. Some cases don't get knocked down. It just depends on whether there were legal errors by the judge, on whether, it's against the weight of the evidence, on whether, and then they also look to precedents. But it seems to generally be going in the direction of higher verdicts, because in a lot of jurisdictions all over the country, people are winning these multi-million-dollar results, like 10 million here, 50 million there, 63 million there, even 100 million or more. So it's moving in that direction. And even in New York, which is considered to be pretty conservative, there was that verdict of over 100 million. And then the appellate division sustained it for, I think, 20 million. And that was in a serious traumatic brain injury case. And they said, look, 20 million, that's probably one of the highest sustained verdicts or sustained amounts ever. So as the precedents, meaning the prior cases that they look at, as they start going up, everything's going to go in that direction. So that's a good sign. Yeah. And plus, like, you really don't have any other choice, because that's your recourse, right? Your recourse is to go to trial and to get the verdict. So whether you keep the verdict or not, that's like a question of law. But like, what else could you do? The only other thing you could do is just call them up and say, hey, pay me a fair amount, like pay me $1 million. But they'll just laugh and say, no, why should we? Make us pay you, right? Make me pay it. Why do I have to just pay you? I could pay you just 10,000, So that's your only recourse. So that's why you go to trial, because there's nothing else you can really do. And then Cole says, I did not go to deposition. Can I just file a motion for summary judgment? You may be able to. Yeah, it really depends on the type of case that you have. So basically, yeah, you could. It just depends on the type of case you have. Like, if you have evidence to show that you're entitled to judgment as a matter of law, you don't have to do a deposition. For example, if you're stopped at a red light and you've been stopped for, let's say, 30 seconds, and now the defendant rear-ends you, well, you don't need to do a deposition. You can just sign an affidavit. You can enclose photographs. If you have dash cam video, you enclose that. You could enclose, an affidavit, like a signed affidavit. You can enclose, like I said, dash cam video, photographs, affirmation from your attorney, the certified police report, whatever evidence you have, just give it all over. Make a motion. It should be granted, because you're stopped. The guy rear ends you. It's completely their fault. That's it. It's really simple. So there's no reason for you to wait, like, say, 6 months or a year just to get a deposition where you're going to say these same things, unless they have evidence that this is not true, right? But if they don't have evidence, then you're going to get summary judgments. You don't have to wait. Yeah. And then Mastermind says, what's the percentages of your cases that have been surveillanced? Okay, well, I don't know. I don't keep a percentage of that, but I would say in terms of surveillance, the ones that are going to trial, usually those, because, if you're just in discovery, they don't usually do the surveillance. So usually the ones where you're going to go to trial, the two most recent ones that I could think of was the one that I did just in June, right? Like last month in June of 2024, where they did surveillance of this nice gentleman who was driving his car, and a Con Edison manhole cover was not properly placed in the road, and it popped up like a seesaw, and his car went up in the air and it flew up, and he had like a bad back injury where he had to have surgery. So they exchanged surveillance just of him walking around the neighborhood using a cane. They were saying sometimes he doesn't use the cane, and then they had this crazy thing where they went to his car and they bought, I think it was them, because I don't know who else would do this, bought like a huge bag of cat litter, like one of those 50-pound or whatever the biggest bag of cat litter you could buy, and put it like right on his wheel, like, in between, I guess, the curb and this is in the Bronx, New York City, in between the curb and his wheel. So thinking like he's got to drive somewhere, he's going to bend down, he's going to move it, and we're going to videotape this guy moving this big, 75-pound bag of cat litter. But he just saw it. He was smart, because we prepped him. He just said, okay, fine. We left the cat litter there and just went, and went back home or whatever. So he didn't fall for the trick. But yeah, they try that. Usually on cases where you're going to go to trial, because they want to show that you are not as hurt as you claim to be, or that you cannot do something that you say you can. So if you testify in a deposition that you cannot do something like play baseball, and then they have you, playing baseball, that's not good, right? Because then you're a liar. So that's what they're going to use against you. So you have to be careful with that. And then Louis says, my lawyer doesn't answer my questions about how my case is going, even though it's been going on for 7 years here in New York City. Oh, that's not good. Yeah. So give me a call. Just text me 347-566-9595. If you text me, I'm happy to jump on a call. We could chat. I can give you some more information. And also I could look up the case, because there's a public court filing. So in the public court filing, there's e-law. There's also the New York State Civil Electronic Filing System called NYSIF. So I could look up some stuff. I could give you my feedback just based on the documents. If it's going on for 7 years, there must be something happening. That's kind of weird. So yeah, I'm happy to chat with you and give you my input. I did that for somebody, I think a few people this week. So I'm happy to do that. Okay, let me see, what other questions do we have? Shaq. Oh, and he sent some, thank you. Thank you so much for doing that. That's great. They're supporting the channel. That's awesome. So Shaq says, Mr. Frekhtman, I watch all of your videos and I like them all. I wanted to know, how is the excess policy retrieved once the auto policy limits are tendered? How are they negotiated? Yeah, sure. So basically what you do is, you just do it all at once. You find out how much insurance there is. So they could tell you, okay, the primary, for example, is 250, and then we also have 1 million in excess or umbrella. So you just negotiate it all at once. They ask you, what's your demand? And it just depends on your style, or rather your lawyer's style of negotiation. The typical way most lawyers negotiate it is they just say, my demand is 1.25 million, right? The 250 plus the 1 million excess. That's all you have, and I'll take 1.25 million. And then the insurance company might say, oh my God, that's so high. How about, less? How about we offer you like 75,000? And you start negotiating and you try to come to a middle. Like you're never going to get the 1.25 million, but you're not going to take the 75,000 either. And they're thinking they're going to meet somewhere in the middle, maybe like 300, 400,000. So that's like the typical way that most lawyers negotiate. The other way is just to do it like the way I was talking about, which is more like a settlement opportunity, is to say, look, evaluate the case objectively and say, what is this case truly worth? And if you feel like it's truly worth 1.25, you can say that. Or if you feel like it's worth a little less, like 950 or $1 million, you could say that and just say, look, pay me this number, like for example, $1 million within 30 days. If you do, the case is resolved. That's your opportunity. But if you don't, we're going to go to trial. And at trial, we're not going to ask for $1 million anymore, but rather we're going to tell the jury that when you match up the law and the evidence, a verdict of 5 million will be justified in this case. So tell that to your policyholder that's paying you, right, premiums for this insurance company, for this insurance policy, paying the insurance company. Tell that to everyone. Tell that to the decision makers, because if we do get 5 million, who's going to pay for it, right? You only have 1.25, so who's going to pay the rest of it? Who's going to pay the other close to 4 million above that, right? And that might breed some kind of problems. And then they usually either pay you the amount, or sometimes they come up and they pay you much more than they would otherwise. And that's, well, some people call those bad faith letters. So I would do that. I really like those. They really work. And they do something. I can't say every time you send a letter, they're just going to pay you all the money, but they either pay you the money, they fire their lawyer, they hire a new defense lawyer, or they, I don't know. It always leads to something. It always leads to something. And most of the time, the case does end up settling, which is good. So, yeah. But there's no special process in terms of like, you do have to get the primary policy first. They have to tender the primary. And sometimes you have two different carriers. Like the case we just settled, the case a few weeks ago, and it was for 1.2 million. And so we had 1 million with one carrier, and then we went into the excess for another 200,000. So we actually got the check for the 200,000, the excess carrier. They just sent it right away, but we're still waiting on the other check from the primary carrier. So yeah, absolutely. And then Cole says, I like your cartoon on YouTube. Looks very nice. How do you do that cartoon thing? Oh, Superman. Oh, okay. Oh, that, I think, I don't do that myself. I think that's one of our web guys that does that. I think maybe he uses AI to do that. Oh, thanks. Yeah, I'm not exactly sure, but it might be one of those AI apps that draw. So he probably puts a picture of me, and then the AI does like a Superman thing or whatever. I don't know. We try to balance it out. We do a little of that. We do a little of the regular thumbnails. Some people don't like the AI. Some people do. So, but thanks. Yeah, if you like it, that's great. Okay. And then Mastermind says, if there are two plaintiffs and he settles, but I go to trial, will I be able to get the full amount of umbrella policy in trial? So there are two plaintiffs and one of them settles. Yeah, it just depends on how much money there is. Like, the way that the policies are written, usually there's an amount per plaintiff, and then there's an amount for the accident. So the one for the accident, like for example, if you see 100 over 300, the first number is the most any one person can get. And the second number, the 300, that's how much they have for the whole crash. So even if there are like 100 people in the crash, right, they just share the 300. So it just depends on how much money there is. So if there's two plaintiffs, he settles, let's say he settles for the 100, so then you can get another, I guess, 200, right? Or actually, no, wait, because if you're one person, the most any one person can get is 100. So in that example, he can get 100, you can get 100. So it wouldn't affect you that he settled. You could still go after it. If there's umbrella, yeah, you can go after the umbrella as well, because I'm assuming he settled for less. So it just depends on how much money there is, but your lawyer should be able to tell you that. And then Louis says, I'm afraid to leave to another law firm because it's 7 years already, and I don't think anyone else will like to take over such a case, even though it's a work accident with over 8 major surgeries. Yeah, well, it doesn't hurt to chat. You could always just chat with an attorney, like whether it's me or someone else, and then they just give you some advice. To be honest, like when I chat with people, I'm usually not like trying to, take their case, or I'm usually just giving them advice, and then they stay with their lawyer. I mean, sometimes if they're really upset with somebody and they have a case and it's here in New York and I feel like I could help them, I will take a case. But it only happened a handful of times. I would say most of the time I just tell them, look, you have a good lawyer. And that's kind of like the service I could provide also, is I could review the court file just to give you my opinion as to what I see in the public court file, whether it's e-law or NICEF. But then I could also do a search on the lawyer, right, the trial lawyer, and say, hey, this lawyer has these verdicts, and I email you the verdicts. So you can see, hey, this is what the lawyer has done in the past. This is the settlements this lawyer has won. These are the verdicts this lawyer has won. Then you could think, okay, I'm happy with this. They won $1 million. Or, hey, I don't want this because this guy only won like $2,500. I don't want $2,500. I got to get rid of this guy. So it just depends, so I could do that. But yeah, like I'm happy to chat with you. I don't know, 7 years. It says that also they've won summary judgment. So yeah, if you won summary judgment, that's good. So it's a damages only case. So it should be a big case. I don't know why it's taking 7 years. I don't know like what county it's in. But yeah, just text me. I'm happy to jump on the phone and we'll schedule a call. We can go over everything and I could give you my input. And if it makes sense, like if you need my help and it makes sense for me to help, I'm happy to help. I have helped a few YouTubers, like this one that I just settled for $1.2 million. That was somebody who found us on the channel. The case that was in June was $2.2 million. That was the Con Ed manhole. That was $2.2 million settlement. That was also a YouTube viewer. Yeah, this one was a work accident where it fell on a makeshift little staircase that you could move around, but it wasn't attached to anything. The stairs weren't attached to the ground, and there was no like railing and there was no side. Everything was like you could move it around. So when he stepped on it, the whole thing like toppled over. He fell and he had a hip replacement, but it was an aggravation because he had it before. He was told that he already needed a hip surgery, but it was made worse by the fall. The fall kind of made him have it right away, as opposed to having it at some point, right? Like 5 years, 10 years down the road. So that was a pretty good result, 1.2 for that. That was also a YouTube viewer. And there was another lady where we went to court in Westchester and we got 575, close to 600,000 for her. And she was also a YouTube viewer. But I prefer to do the cases fresh. Like if you have a case where you don't have a lawyer or someone that just had an incident, I prefer to do the cases fresh because then I could build them up the right way and get the maximum on them. Sometimes when you get them from with other lawyers, you're limited because the other lawyer might mess something up and then it's just nothing you can do. I mean, nothing anybody can do because it's like they already did it. They already did something. Like, for example, in this case, I mean, it wasn't really the lawyer's fault, but one of the doctors had some emergency and he's like, well, I'm not doing anything for a year. So now how are you going to go to trial? He's the surgeon. Then you have to go find another doctor, but the other doctor is going to just say, okay, I reviewed the operative report, but he can't know what actually happened during the surgery. He wasn't there. He's not the surgeon. So it's weaker. So it was good that we ended up settling for 1.2. And sometimes the lawyer will ask the wrong questions in a deposition or fail to question a witness. And then that's the law of the case, because you can't just, maybe you could subpoena them, but you don't know what they're going to say now. There's no depositions. There's a lot of risks. So it's always better to, to do it right from the beginning. Okay. Let's see what other, Air Congo. I think I missed this question. Mr. Arkady, hi. I suppose to have a mediation, defense lawyer said need to talk with codefendant. It's a product liability case. Why would he say that? Okay, so I think probably because the defense lawyer maybe wants to go to mediation and offer you money, right, to settle, but he wants to talk to the codefendant because the codefendant has another law firm, has another maybe insurance policy, two separate, and they want to talk as to how much each of them is going to offer you. For example, one of them could offer you $1 million, another one could offer you 500,000, whatever it is, So probably that's why they wanted to talk to them to see, because if one of them wants to offer you, let's say $1 million, and the other one says, no, I don't care, I'm not offering this guy a penny. Well, then the one guy was like, well, why do I have to bear the brunt of everything? Maybe they don't want to offer anything either. Let's go to trial. Or, they have to come up with some kind of strategy. and then your lawyer could speak with them too at the mediation and push them to give you the maximum amount. So that's always the best. Okay, let's see. Aaron says, I had a steroid injection that only helped for 2 days. Doctor is asking if I want to do an intradiscal bone marrow steroid injection or surgery. How does the value compare between these, if you know? So depending on what type of surgery, I guess. I don't know what type of surgery he wants to do, but the intradiscal bone marrow steroid injection, I haven't really heard too much about that. But if it's, I guess, a bone marrow steroid injection between 2 discs, it could be, I mean, I know an epidural steroid injection, which is another type of steroid injection. Those cases go for anywhere from like 20, 30,000 up to maybe 100, 150,000. I mean, it could be more, but that's usually what they go for in my experience. So if this is more of a bone marrow injection, that might be worth a little more than just an epidural. That might be into the 200,000 or 300,000 range. But I think a surgery is always going to be even more because a surgery is more invasive. It's more serious compared to a injection. And then Steven says, what happens when medical treatment is done? So yeah, when your medical treatment is done, depending on, where you are in the case, but if your medical treatment is done, you usually send a settlement package to the insurance company. And then you give them like 30 days or some reasonable amount of time to review everything. And then you could start negotiating the case. If it's a small case, you could do it without even filing a lawsuit. If it's a bigger case, you would do it. And then, you're still litigating the case through depositions, through discovery, through putting it on the trial calendar. But if you're all done with your treatment, you give them all the medical records. You say, look, that's a good time for a settlement opportunity letter to say, look, they're all done with their treatment. This is what it's worth. Are you going to pay $1 million or whatever it is? If not, then we're going to go to trial and just kind of like lay it all out. So what the defense lawyers do is they send letters to the carrier, right? So they're kind of like the carrier is their boss, right? The insurance carrier and the insurance adjuster. So what they do is they report to the carrier and they write a report saying like the plaintiff is like a 50-year-old gentleman. He's a little overweight or, he's this, he's that. We found a prior history. He had prior accidents. His lawyer is, this guy, and this lawyer has tried a case, but he hasn't tried a case since 2010 or, whatever the situation is. And they send like a detailed report, all the risks, all the, possibilities, and then they give their assessment or their evaluation. Like, we think this is worth, $50,000 for all these reasons, because this lawyer hasn't been in court since 2010. And the guy's like, had prior accidents. He could be called a fraudster, whatever the situation is. Or it could be the opposite. It could be good. It could say, look, this lawyer just went to court and won like, $3 million. He's really good. And this client is really a sweetheart. They have these photos. They have a lot of other witnesses, before and after witnesses from the client's life. So basically, the point is that these insurance companies, right, are getting these letters from the defense lawyer, and it's like a report. And then the insurance company is basically listening to the lawyer because that's their client. They hired that lawyer. And so, because the insurance company otherwise doesn't know what's going on in the litigation. I mean, they could read the depositions themselves, but they're not going to know all the different things unless they get these reports from the lawyer. So what some lawyers do to, help the settlement is actually for the plaintiff's lawyer to write these letters to the insurance adjuster and to say, look, are you getting a letter from the defense lawyer saying X, Y, and Z? Well, here's a letter. It's actually not X, Y, and Z. It's actually this. It's actually that here are the verdicts. Here are the injuries. Here's the animation. Here's the 3-dimensional MRI or the colorized MRI that I'm going to use. And it's kind of like almost putting pressure on them to say, look, here's another assessment. And that actually works as well. So that's actually not a tactic that I've employed myself, but I wouldn't be against it. I would maybe try it. I know some of the top lawyers do that. So it's interesting. They write, so basically the plaintiff's lawyer is writing a letter to the insurance adjuster saying, don't just listen to the report you're getting from the defense lawyer, but here's the real skinny. Look at the other side. And then, it could be much more higher. So, And then Cadian says defendant keeps on putting off the deposition, or I think deposition. Yeah. Now they say they want to do a mediation. Do you think that's a good idea? Well, I mean, if they haven't done a deposition, then maybe not. It's hard to say. Like, I don't like to do a mediation unless they give you a good faith monetary offer, So like I gave the example before, like for example, if I want to settle a case and my target is $1 million, okay, and if they offer me like 300,000, I can say, okay, well, I'll go to mediation because you're giving me a good faith offer. It's something, it's 300,000. I want to get $1 million, and maybe I could negotiate, and maybe we'll settle the case for like 800 or 850. So that's okay because I'm pretty close to my target, and you're giving me that good faith of 300. But if they just say, let's go to mediation, and they don't give you anything, and they're refusing to put money on the case, I wouldn't necessarily agree to it, because what I've seen so many times is they use the mediation as a way to breed discontent between the client and the lawyer. So basically you show up, the client gets all excited, we're going to mediation, my case is going to settle, oh yeah, yippee-ki-yay. And then you show up and they just like, oh, this case is so bad, we have these priors, we have these claims on you, oh, we don't even agree, you don't have liability, look at these cases we found, and we think it's worth like 10,000 or something. And meanwhile, you're thinking you're going to get like $1 million, and then you look at your lawyer and you're like, why did you bring me here? Didn't you speak to them? Why did you bring me here? You brought me here, got my hopes up for them to tell me that it's only worth 10,000. And then people just get really, really upset, and they know that, right? The insurance companies know that, so they use that as a tactic. So I wouldn't really agree to mediation unless there's a good faith monetary offer, because if it's likely to lead to a settlement and likely to have some kind of like fruition, fruition meaning bear fruits or, lead to something, yeah, do it. But if it's just going to be like one of these like breeding discontent and having you get mad at your lawyer be mad at you, what's the point of that? Who does that help? It just helps them. It helps the insurance company. Yeah, so I definitely wouldn't do it then. So it's hard for me to say which one it is. But if they just ask for mediation without more, it's hard to say. Okay, let me see here. Louis says that would be great. We can call tomorrow. Okay, yeah, let's chat, because that's a serious case, because he's saying that he's still doing medical treatment, spinal cord implanted, and another fusion. Yeah, that could be a big case. If that's worked up the right way, that could be a really, really big, I think it sounds like a labor law case if you're a worker and you have summary judgment, because labor law cases are really good because the general contractor and the owner of a job site has to provide what's known as proper protection to the worker. If they don't provide proper protection, then, basically they're liable. And so if the worker falls from a height, if it's gravity related, they're strictly liable, the owner and the GC. And they have large insurance policies because, New York City, you have big buildings going up. So those are usually really strong cases if they could be worked up the right way. And definitely with the damages. It could be big damages. Those could even be like, 10 million or more. It could be huge cases. Okay. The mastermind says, will the 9% interest in winning summary judgment allow the defendant to be forced to pay over the policy limit? Well, yeah, if you get a judgment, they have to pay you the judgment. Usually it's 9% on top of whatever, the judgment is. So for example, if you get summary judgment today for a crash that happened like a week ago, you just have the judgment. Then you still have to wait, and then you get a trial, let's say in a year from now. And at the trial, the jury says, well, this is worth 300,000. That's your verdict. So now you get 9% on that verdict. So that's the way that works. So yeah, they could pay. You have the judgment. I don't know if they would pay over the policy. Some insurance companies do. If it's like higher than the actual limits, they'll still pay it. It just depends on the company. Okay, Jenna Ram says, hi, I had a bimalleolar ankle fracture last year in a slip and fall in a big hotel, had a second surgery to remove the broken hardware, dealing with arthritis and PTSD. How much do you think my case is worth? Well, if the liability is strong, meaning the reason that you fell was their fault, there was like a safety violation, then I think a bimalleolar fracture like that with surgery and PTSD, that could be a lot. I've settled cases like that even for like, 850, $1 million, even over $1 million. This case that we just settled for 1.2 was a hip fracture, also like with ORIF. Actually, it wasn't ORIF, it was a total hip replacement, but it was an aggravation. But bimalleolar, trimalleolar, I would say anywhere from like, 400s, 500s we've settled. I think we had one for about 600. That was a slip and fall on ice where they didn't clean the ice in front of their building in Brooklyn, and he fell. He also had a trimalleolar with surgery, like you talk about, and it was about, I think, 600,000. So they all vary, but I would say it should be significant. Also depends on where. New York, I mean, the values might be a little higher than like somewhere like Oklahoma. I don't know where you are. So, but I would say generally it should be pretty high. And then Aaron says, it's where they take bone marrow, about the bone marrow from a different part of my body and inject it into the disc. It's supposed to last up to 2 years. I'm more worried about long-term outcome compared to a discectomy. Oh, okay, yeah. I mean, bone marrow, that's pretty serious. Yeah, I mean, I don't know about the values of that. I don't know if that's something kind of new. I haven't heard too much about that, but I could do a little research and see what the values are. And then Crystal says, do you have to wait until treatment is done to send a demand if someone has a permanent injury? What if you always will need treatment? Right, so then you get that from your doctors in the narrative report. When the doctor writes the narrative report, like the final narrative, they'll say, I think that this person has a permanent injury, that's a lifelong forever injury, and they're always going to need it. And then they actually outline it. They talk about future medical expenses like, prescriptions and physical therapy and certain, medications that they'll need, certain future surgeries they'll need. And then they outline all that. And then the economist could then take that and also talk about, reduce it like the present value and talk about the future costs, because, based on how long you're going to live, because some people, they're going to live like another 50 years. So over 50 years, what is the cost of all this? And that could be like into the millions of dollars. So that's the way to do it. And then you could recover that. Yeah. And Aaron also says, if I take a smaller settlement with this injection and then need surgery down the road, I'm kind of screwed. If I do the surgery, at least I get that value, even if it causes other problems. Yeah, that's true. I mean, if you do like just the injection, you settle for less, and then you end up needing the surgery later, you won't get paid for the surgery. So if you're gonna do the surgery, I mean, you could try the injection now. If the injection doesn't help, like in whatever amount of time, 3 months, 4 months, then maybe do the surgery. That way you get paid completely, fully compensated, as opposed to like settling for a small amount for the injection, but then like what if like 5 years down the road you need the surgery anyway? Now no one's going to compensate you. But also speak to the doctors, maybe get a second opinion from a different doctor, and speak to your attorney, see what everybody recommends and see what you feel comfortable with. Okay, and then Viral Guy says, I got to find a pretrial conference coming up in August. What should I expect? I had a discectomy, laminectomy, epidural, pain management. I'm 100% disabled, and it's been almost 5 years. They seem pain management, and I still can't work, and I'm only 33. Also for pain management. Yeah, so a pretrial conference is basically just that, pre-trial. So they talk about things like whether the case could be settled, what's going on with the case, when the trial will be, if there's anything like subpoenas or documents, like, what you expect. Usually it's just a conference. And then if the case can't be settled, then they'll give you a final trial date. And then that's when the case will either be, you'll pick a jury, you'll start opening statements, the case could be settled, or if it's not settled, then it'll go to trial and the jury will render a verdict. And then Hassan says, hello, I had a deposition yesterday. I think it went well. If the case does not go to trial, according to your experience, how many months does settlement take? Oh, okay. So, I mean, there's not really any amount of time, right? Because settlement is not really like a process where it takes time, the actual settlement. Settlement could be at any point, right? I could be doing nothing. I could be sitting there just twiddling my thumbs, just bored in my office, and I get a call and they're like, hey, we're calling you on the Jones case. We had it reviewed and we believe we want to make you an offer of $250,000. And then I could look and I could be like, oh, wait, the Jones case, I only thought that was worth $100,000. That's a great offer. I'll take it. Okay. And then now the case is settled. So, it just depends. But I mean, it's not that easy. They're not just going to call you and throw money at you. So you have to, as the plaintiff's attorney, build up the case to put all the pressure on them to make them settle by sending these settlement opportunity letters, like I was talking about, by litigating the case, by doing a good job at the deposition, preparing the client, doing everything proactively and building a really strong case. Discovery, getting the right discovery, documents, maybe going outside the box and doing like former employees or non-party witnesses, all these things. So settlement isn't really like You know what I mean? I don't know how long it could be. I've settled cases before even filing a lawsuit, and for big amounts. Like we settled a lead paint case for a child for like $275,000. We never even filed a lawsuit. We just had the lead indication. We sent the letter. They contacted their insurance carrier. They started negotiating. It was a really minor lead poisoning, but it was still a lot of money. And we settled, for a big amount like that, over $250,000. So it could settle at any point. I mean, most cases do settle like after depositions, closer to the trial, most cases. So if you've had your deposition, that's good. So it shouldn't be too much longer. And then Steven says, can you talk a little bit about ACDF with good recovery but limited range of motion, a truck accident, and adjacent segment disease for future medical expenses? Yeah, sure. I mean, like that's, I could do some more videos about that. I probably should look into some recent verdicts, but ACDF is the anterior cervical discectomy and fusion. So they go in through the front, which is anterior, and they cut, and then they basically put in the cage, the discectomy. They remove the disc that's injured because the disc has exploded and it's leaking and it's touching the nerve roots. So they remove that disc and they put in an artificial like bone graft, and it's like a cage where they screw into the vertebrae, into the bone, and then you have that permanent cage. So it's a serious injury. And the adjacent segment disease is known medically that if you've had, let's say, a fusion at C4, C5, that you're likely to also need one at the next level, the adjacent level, like C3 or C6, right? So then, yeah, a good lawyer, what they'll do is they'll send you to the doctor that'll put that in the report that you have this adjacent segment disease, that you're going to need this other surgery. And then they'll also use maybe an economist to talk about future medicals, and that'll be in the future medicals. And you could have high future medical expenses, like millions of dollars. Like we had one for 2.6 million. I think it was 2.6 million on this case that we did this year. So just medical expenses were 2.6 million, according to the doctor and the economist together. So it could make the case worth a lot more. So I do recommend doing that, and I could do some more videos about that, either like verdicts, where I go through verdicts in a particular city, like a major city, like maybe, I don't know, Miami or New York or Atlanta or Los Angeles, and just talk about ACDF verdicts. I could also do, just generally a little bit more about the medicine. I can read a little bit, maybe outline that, and then do a video. I think I did a few when I had that other trial. I had a trial in August of 2023 that ended up settling during trial for 3.5 million. And that was a really involved ACDF, because he had an ACDF, but then the doctor had to go in and do a revision and fix it. And then they had to, when they did the revision, it was more involved. They had to go in through the front, and then they had to go in posteriorly from the back, both surgeries. So the front was like maybe an hour or hour and a half, but then the back surgery was like a long surgery, like a 4-hour. The guy was under for a long time, and they had to put in like the rods in the back. So it was really involved surgery. And I did a lot of research about non-union, adjacent segment disease, all these things. So I think I did some videos, but I can go back and do some more about that. And then RDOT says, I've had all 3 of my neck epidural shots for the year from a car accident, but I'm still having pain. So now my doctor wants to do a discogram procedure to find out what exactly is causing the pain. Yeah, discogram, I've seen that. I've seen a lot of clients have that. Yeah, he says, have you ever dealt with a discogram, and would that increase my value before the next procedure, cervical percutaneous discectomy? Yeah, I think a discogram, I mean, it's more diagnostic, but basically, yeah, I think what they're doing is they're trying to locate exactly where the pain is coming from. So they're kind of like injecting a certain material into the disc until you feel pain, and then they stop, and then they could see like which nerve is being affected, because then when they do the percutaneous discectomy, they could do a better job having done the discogram. So it's more of a diagnostic procedure to like figure out what's the cause of the pain, what's the nerve root that's being impinged, so they could do a better job in healing you. But the fact that you've had it definitely increases the value of your case, along with the percutaneous discectomy. I mean, those cases I've settled anywhere from 300, 400,000 percutaneous discectomy cases, because they are minimally invasive. They do the procedure in the office. Usually it's like 10 or 20 minute procedure. So they're not going to be like as big as fusions, but they settle for like 200, 300, 400,000. I think we had a verdict of like 548 or something, 550, close to 550 on one of those. And I've heard other lawyers get like 600, 500, you know, that as the higher end, but usually a lot of them settle in the 100s, 200s. But still significant. It should be good. And Hassan says, thanks for the answer. Who determines the trial date? Oh, so that would be the court. You know, the court determines the trial date when they're available, or when is it determined in which part? So yeah, usually, I mean, it depends where you are, but in New York, the way they do it is, you know, first you have to do discovery. So that's like taking depositions, exchanging documents. Once you're done with all that, you put it on the trial calendar. You wait on the trial calendar. They'll give you pretrial conferences, settlement conferences, and then they'll put you in the jury coordinating part, like JCP. And then they'll say, okay, well, the next time you come, it's marked final. So you know, hey, that's when you have to either pick a jury, settle the case, or, you know, or you're going to start the trial. So they pretty much tell you a little bit ahead of time. In other jurisdictions, you'll know the trial date. They'll actually tell you, like, your trial date is April 29th, 2025, and that's your trial date. You know, they'll tell you way in advance so you can prepare for it. But in New York, they don't really do it like that. They just kind of have you show up, and then they do tell you the trial date. I mean, they still kind of do tell you at least a few months in advance. Like for example, this case that we did, it was June 10th, I believe. So we knew, I think back in even April, or was it March? I think we started maybe February. Whenever we started the case, we knew that the trial was going to be June 10th, or maybe originally it was like May, and then they moved it like a week or two, but around May, June, we knew it was going to be then. So they tell you fairly early. And then Mass On says, my car was repaired for $3,000. I have PTSD and major depression. Can I get paid? I don't know. I mean, like, it depends on what kind of case it is. If it's like a car crash where you were stopped at a red light, somebody rear-ended you, sure. I mean, just because your car got repaired wouldn't be a reason to be paid, right? It could be repaired for any reason. It could just break down. So, you know. But yeah, PTSD you could definitely sue for. I did a video on PTSD as well, so you could check that out. If you search, I think, my name or PTSD, I did a video, and some lawyers say that PTSD could be as, you know, serious as a traumatic brain injury, but it has to, everything has to, you know, flow together. It has to be the right facts and circumstances. And Derek says the epidural injections can be extremely temporary. Yeah, that's true, because what they're doing is they're putting a steroid on the pain, right? They're putting like medicine for the pain. So you have, let's say, a herniated disc. It's like a jelly donut. If I take a jelly donut and I squish it, the jelly is going to pop out the hole. Now the jelly's outside the donut. That's what you don't want. That jelly is now touching these nerve roots. So if they put medicine on the problem, you still have the injured disc. The jelly is still leaking outside the donut. There's just medicine there. The medicine prevents you from feeling pain because the medicine is like a Tylenol or an aspirin, you know, like a pain reliever. But then that medicine is going to wear off, and when it wears off, the pain just comes back. So it doesn't really solve anything. So for most people, it doesn't help. And then John says, once a settlement's been reached, can the defendants file an appeal? No, because a settlement is like an agreement. So basically they're saying we voluntarily agree to pay you like $1 million or whatever it is, right? And you shake hands and you sign releases saying like, I'm not going to sue you. I'm not going to sue, you know, they put who you're not going to sue, all the defendants, you know, forever about this incident, and in exchange for that amount of money. So it's like a deal. It's like a deal. It's like an agreement. So they can't appeal. There's nothing to appeal because they're the ones who entered into the agreement. Unless, like, you know, there's something where they said verbally, we're going to agree to $1 million. Then they say, no, we're not going to pay. Or the client says, yes, I'll take $1 million. But then later the client's like, now I disagreed. I'm not signing anything. Then you might have to make a motion to have the judge enforce the settlement, or, you know, some other recourse. So, I mean, those things happen, I guess, but it's pretty rare. Usually settlements just, you know, whatever the terms are, they just get settled. And then Mastermind says, on public assistance for 10 years, but had 2-level fusion to the neck because of a rear end tractor trailer. How does being on assistance for so long ruin my past and future pain and suffering? So you were on public assistance for 10 years, but you had a 2-level fusion. So do you mean you were on public assistance before you got hurt, right? So I don't think it really, I mean, it might hurt a little bit in the sense that if they say something like, oh, you've been on public assistance, I mean, you could try to keep it out with a motion in limine, or if you can't exclude it, the evidence of the public assistance, then you could perhaps just embrace it and just say, look, this is, tie it all into your story. Like, why were you on public assistance? Maybe you had a tough time in your life, and just explain it, like front it, just, be honest about it and say it with integrity, and just kind of like front it, meaning like be upfront with it. You don't want to hide it and then let them bring it up, because then it's like, wait a minute, why didn't you tell me about this? But, there's different theories about that. Some lawyers say whoever offers the evidence is kind of like sponsoring the evidence. So some lawyers say, as a plaintiff, don't bring it up and let them bring it up. And then you just say, well, I wasn't even going to bring it up because I don't even think this is important, and just respond to it. So it just depends on each circumstance, right? So there's different theories, and different lawyers do it different ways. There's this whole sponsorship, because like, okay, if I'm going to bring it up, then it must be important, right? Because otherwise, it's my case. I could bring up anything. I can make the case about anything I want the case to be about, and I'm making the case about, this welfare or public assistance. So then the jury might think, well, now that's a real issue. Whereas if I don't mention it, and then they bring it up, and I have a good response to it, then they think, it sounds like nonsense. Let's just forget about this. You see what I'm saying? So I guess it just depends on how you choose to handle it, and how. But so I'm not completely clear on how the public assistance, why you think it's going to affect you. But usually that's like the advice for anything bad, whether it's, public assistance, whether it's like a conviction for felony, is like, try to exclude it. If you can't exclude it, then just embrace it, because there's nothing else you can do with it, really. But I don't think public assistance is really going to, if you could tie it into your story and explain how it all, why you needed it, and how it all ties in. And if it has something to do with the injury, then it could even go increase, because you could say, well, I had to be on public assistance because I couldn't live because I was so hurt. So it could be it shouldn't really hurt you too bad. And then Arkady says the policy is $250-$500, but I already had a lumbar percutaneous procedure and doing that Discogram next week. Okay, so if it's only $250, you should be able to get the $250 or close, hopefully. See if there's excess umbrella. If there's $250 with like $1 million excess, then it could be worth even more. And then I'm a Beam says, hi, sir, slip and fall, Nassau, broken leg, surgery, 3 months later to repair, full arthroscopic surgery, diagnosed with CRPS 1 and 2, dorsal ganglion spinal stimulator, liability is good, unlimited insurance value. Oh, yeah, so that could be a big case. I mean, if the liability is good and you have all those injuries, that could be really big. That could be, it's hard for me to say, just off a comment, but it could be into the many millions of dollars, because if you have CRPS, I think CRPS is a real serious injury. If it's really real CRPS and you have it diagnosed, that could be even like, easily could be like 3 million, 5 million. There have been verdicts for like 8 million, 12 million for CRPS. So that could be really serious. Yeah, so. And plus a spinal stimulator is pretty serious too. So if the liability, Nassau County is not the best venue, but if you have a good trial lawyer, what they'll do is they'll pick a jury, and they'll pick the right jury. If the case can't settle, you'll pick the right jury, so you can maximize it that way. And then John says, it's been 4 weeks and I haven't signed my settlement agreement. Well, I don't know. Does that mean that they just haven't gotten it to you? Maybe because it's summertime, they're a little slow. You could probably call them up. But if the case is settled, like for an amount, you know what the amount is. You don't really, either your lawyers are waiting for the insurance company and the defense lawyers to draft the settlement agreement and get it over to you, and then you just sign it. Or your lawyers could just give you like a template release. You could sign that, and then your lawyers could just send that to them, unless they're saying they have their own papers and they're not accepting. But it's really like, I don't know where this is, but in New York, it's really not we've done it both ways. We have the releases, and we've also gotten it from the insurance company. It usually just takes a few days. I don't know why it would take 4 weeks, but maybe they're just like away on vacation. It's summertime. I don't know. But yeah, I wouldn't worry about it. If it's settled, it's settled. You're still going to get the money. Okay. So yeah, I think that's good. We've been going for almost an hour. We answered a lot of questions. It's almost 6 o'clock here in New York City. So let me know if you have any other questions. Let me see. Let me hang out a bit, like another minute or two, see if anybody has any other questions. I'll be happy to answer. If not, we could wrap it up for today, but maybe do another session. Next week, I'm actually away. I'm going to be out in Montana. I'm going to do a training with Trial by Human. They do these workshops where they work on trial skills and they practice like opening statements, cross-examination, all things. And they're actually really, really cutting edge. They do a lot of things that are real cutting edge, and they're really good lawyers. Like the main lawyer recently won a case for, I think it was like close to 70 million. And then he had another verdict for like 200 million. And this one other lawyer in the group, together with a lady lawyer, they partnered up and they were with some other lawyers, and they were out in the West Coast and had some crazy verdict for like 800 something million. So they're like really amazing attorneys. So I'm going out there, actually me and Rick. I don't know if you guys know, I've seen Rick. Rick was a lawyer in my law firm, and he was with me on some of the recent videos that we posted this week and last week on that case, the $2.2 million settlement, because we worked on it together. So he came to my office and we shot some videos where we did recaps about that case. And I think those are going to be, there's still maybe one or two more. We did a few videos. So anyway, so he's going to go too. So we're going to work on it together out there. So that should be fun. It should be very, educational. And I like that stuff because I take a lot of notes, I kind of immerse myself, and then I come back and I start applying it. And that's like really good because you apply what you learn. And maybe what I'll do is whatever I learn, if it's something interesting, when I come back, I will, I'll share it with you guys. We'll do some videos about it, and it could be very educational content. So it could be some new topics. And by the way, if anyone has topics that you want for a video, just let me know, because I'm going to be doing like a content calendar and probably shooting more videos this week or possibly the week after next. And then we could go live again, probably the week after next, probably that week of August. What was it going to be like by the 14th or so, 14th or 15th? I'll probably be able to, because this thing is, I think, from the 7th of August until the 10th or 11th. So it's like pretty much all of next week or most of next week, but then the following week, like the 12th, or I think August 12th is a Monday, so that I'll be available. So let me see, any other questions? We had something, but I think it got retracted. If not, I guess we'll call it a day. But thank you, everyone. Thank you for being here. Please like and subscribe to our channel. Our goal is helping serious injury victims and families, and we want to do the best that we can for our clients and get them full justice. Here's a comment. It says, Kevin, hey, sir, I was rear-ended. It says, by a DeKalb County cop. Oh, okay. Yeah, so if you were rear-ended by a police officer, I think that should be a fine case. I don't see, unless, if the officer was responding to an actual emergency and they had lights and sirens on, then it could be a little bit more difficult because you have to prove they were reckless. It could still be one, but it's a little bit more difficult. It says no emergency call. No, okay, so then it's just like a regular car crash. So it's just negligence then, not reckless, but just negligence, meaning did they fail to use reasonable care? And if he rear-ended you, he didn't use reasonable care. So that's a good case. As long as you get your medical care and you have an injury, that could be a substantial case. And the good thing usually about suing a police department is there's no cap. At least in New York, there's no cap, meaning it's not like $100,000 policy. It could be anything. It could be $1 million, it could be $2 million, $3 million. There's no ceiling on it. So that could be good. Okay, everyone. Have a great day. We are here for you. Please like and subscribe to our channel. Let us know what questions you have, and all the best. Okay, have a good night.